Why do franchise laws vary so much internationally? Have you ever wondered why franchise laws are not the same everywhere? It is a fascinating topic that reveals a lot about how different countries operate. Let's break it down. Franchise laws differ internationally due to each country having its own legal system, economic conditions, cultural values, and regulatory priorities. These factors shape how franchising is governed and enforced. At the core, franchise law includes rules about disclosure, contract terms, intellectual property protection, and the rights and obligations of franchisors and franchisees. However, the way these elements are managed varies significantly based on national legal traditions and policy goals. One major reason for these differences is the variety of legal systems. Countries may follow common law, civil law, or mixed systems. For instance, in the United States, there are federal franchise disclosure laws along with state regulations. This creates a layered approach. In Canada, franchising is mainly regulated at the provincial level, resulting in different rules across provinces. In Europe, many countries relying on civil law traditions and ethical codes rather than having uniform franchise statutes. Another reason is the focus of regulations. Some countries prioritize disclosure and transparency to protect franchisees. They may require detailed franchise disclosure documents. On the other hand, some nations emphasize fair dealing and ethical conduct. For example, the European Union places a strong emphasis on ethical franchising practices and data privacy under the General Data Protection Regulation. In contrast, United States franchise law is more centered on disclosure and contractual relationships. Economic conditions also play a role. Emerging markets may not have specific franchise laws. Instead, they rely on general commercial or contract law. For example, India does not have dedicated franchise laws. It uses a mix of contract law, consumer protection regulations, competition law, and foreign exchange rules to govern franchising. This can create challenges for international franchisors, especially regarding dispute resolution and fees. Cultural attitudes toward franchising can influence legal requirements as well. Some countries have well-established franchise markets with strong enforcement agencies. Others may depend more on civil litigation or administrative oversight. For instance, France has detailed disclosure and enforcement mechanisms, while the United Kingdom focuses more on principles of good faith and fair dealing. Lastly, international organizations like the International Franchise Association and the World Intellectual Property Organization work to promote guidelines and best practices. Their goal is to harmonize franchising laws globally. However, these efforts do not replace national laws but serve as frameworks for improving consistency in franchise ownership. For franchise owners, understanding these variations is essential. Franchisors must navigate different legal environments, adjusting their disclosure documents and contracts to comply with local laws. Franchisees may experience varying levels of protection, with some countries offering detailed per-sale information while others provide minimal protections. Intellectual property rights must also be secured in each jurisdiction separately due to differing enforcement standards. Additionally, employment, labor laws, and data privacy regulations add layers of compliance that affect franchise operations internationally. By grasping these differences, anyone involved in franchise ownership can better manage legal risks, ensure compliance, and optimize growth across borders.